911 location of your emergency.
Breaking news out of North Idaho. Moscow police are investigating a homicide on King Road.
Is she breathing?
No.
So 5'10", all black. Could you see what color his eyebrows were or anything like that?
No, I don't remember what his eyes look like either.
Officers discovered the bodies of Ethan Chapin, Xana Kernodle, Maddie Mogen, and Kaylee Goncalves, but no weapon has been located at this time.
Arrested. That's 28-year-old Bryan Kohberger in custody today.
Mr. Kohberger allegedly stalked one of the victims. That's false.
We do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area. There are many residences in that area. It's a dense population of mostly college-related occupants.
Hey guys, how's everyone doing today? Happy Tuesday. Guess what? We got to keep 2 fish today. Dad just finished cutting them up and putting them in the freezer. Holy shit, we got to keep 2. And I don't look as red. I might actually get a little bit of a tan off of this sunburn this time. You know how rare that is? For me to actually tan instead of just straight up burn and then go back to being bright? Who knows? I guess we shall see. Okay, today's topic. We went over some of this in the members only live that we did Monday. Wait, today's Tuesday? What is today? Today's Wednesday. I am off by a day, bro. Happy Wednesday. I felt like it was Tuesday because I had tacos today. Tells you where my mind always goes, right? So which day is it for the food day? Because, you know, that's what we do in this house. We are themed here. Seafood Sundays, fast food Fridays, taco Tuesdays. We do all of that kind of stuff. So yeah, today's Wednesday. Well, that's good to know. We're farther along in the week than I thought we were. Okay, anyway. So today we are going to be talking about this lawsuit situation because like we have all these other lawsuits happening in this case, we now have another one that we have to pay attention to. The Idaho Statesman has begun digging into the financials of the case the same way that it seems Chris McDonough's wife, I think her name is Karen. I don't know for sure. I think her name is Karen. She also had gone through some of the financials here, told us a couple of things, but now it seems like the Idaho Statesman is trying to do the same thing. The way that it's being told, and we are going to go back over, and again, if you were in the members only live, you already saw this interview, but for the sake of today's subject, we are going to go over just the part where Kevin Fixler and Brian Inton are talking about this lawsuit so that you can kind of see the way that Fixler is describing everything. Plus, on top of that, I'm also going to tell you what I'm thinking from all of this. So the way that he is describing it is that when there was a change of venue, this special judge got placed over like the financials for what could be spent in the case until trial, basically. And Kevin Fixler in the Idaho Statesman, I'm sure it was probably Kevin Fixler that initiated it because he seems to be the one that's the only person there that's writing about the case. But with the lawyers for the Idaho Statesman behind them, so technically just the Idaho Statesman, I guess, since Kevin's name's not actually on anything. He's just the writer, not the entity. But anyway, they want the financials. They want to see what all was spent. I want to see what all was freaking spent. They did all kinds of crap in this case. There was venue changes. There was the way that the state defenders got paid that changed into a completely different department, completely different. Everything got completely restructured right in the middle of this case. I want to know where the money went. Hell yeah, I want to know where the money went. Millions of dollars went where? Went where? Went where? I don't understand. But apparently Ann Taylor is trying to block some of this information from coming out. And I don't really quite understand why. The only thing that I can think of is that there's still something happening in the background and releasing this information will show their hand. But if that's the case, then why not just come out and be straightforward about it at that point? Like, we are still in the middle of representing Mr. Kohberger, and until our representation is over with, this is still, whatever. There's probably a different way this could go about it than making it seem as if she's being super shady, unless she's just straight up being super shady, because we can't trust her. We know this now. So I don't know what's happening. I don't know what's going to happen. I don't know what's trying to be hidden. Again, I don't know if it's got intention because there's something coming. If she's actually trying to hide some shit, I don't know. But the sums that they're coming up with at this point is like $8 million. And according to Fixler, that's not including the prosecutor. That's not including all the things the FBI did, which was every freaking thing in this case. Again, I want you to try to find one thing that the feds did not touch. From the DNA to the Amazon shit to the car and everything in between. They did it. They organized the trash pool in Pennsylvania. They literally orchestrated everything. And none of that has been included in this because the FBI doesn't have to give up that information. Therefore, Kevin Fixler and his little team, including Inton over there, are gearing it towards, oh, it's Kohberger. Oh, it's the defense team. They did all these things. They did all these things. What about the state? What about the state and all the testing that wasn't done? Where did all of the money, where did the money go? What did it get spent on? When we see all of the unknown DNA, unknown hair testing, people that weren't even placed into the system, stuff that's not answered, people that weren't talked to, in interviews that weren't taking place that should have been, information missing. It's not like they were paying attention and paying extra money for people to be organized or to keep storage stuff done. Like, where'd the money go? Millions of dollars. Where did the money go? Even if you take away the $2 million that apparently was spread around between Ann Taylor and the rest of the attorneys there, where's the other who knows how many millions of dollars? What did it get spent on? I don't even live in Idaho. People that live in Idaho, regardless if you give a shit about this case or not, you should care where your, I don't know, at the end of the day, probably $15 million went. Because the $8 million doesn't include the other side of things. Or like a lot of shit that also is on the defense side of things. There's a lot of information missing. I want to know where it went. Idaho should be demanding to know where it went. The fact that the Goncalveses aren't bothering with this part of this is also interesting. Like, they don't even care at all about the manipulation and the obvious money issues. Interestingly enough, it doesn't seem like they do, but who knows? Which, by the way, we are going to be going over that interview tonight. I have it scheduled for 8:15 tonight, because we should only be live here for maybe like 2 hours or so. So then around 8:15, we're going to go live to go over that new interview that they just did. Should be interesting. It should be quite interesting. Okay, let's see. Let me get this pulled up real quick. So we're going to go over just a little piece of this interview between Brian Inton and Kevin Fixler. Let me pull up the transcript, though, so that we don't have to go through too much of it. Because I only care about the part he's talking about right here when it comes to this lawsuit. Well, it was further down into this conversation. I just want to make sure we're not going to listen too much of it because I don't want to deal with them too much. Okay, let's see. I guess right around this spot would probably be all right, I guess. No, maybe not. That's where he says we're going to talk about it later. Okay, hold on. I think I found a good spot for it. Okay. So this is what we're going to listen to for a few minutes. And then we're going to pull up these records because Sarah grabbed all of these and posted them yesterday. And there's 1, 2, 3, 4, 5. No, this is the article. So there's 4 altogether documents that came out from her grabbing stuff from the court. So let's listen to Fixler describe the issue because he's going to talk about what they were asking for, what the judge is doing, and what their next steps apparently are. Because it was really difficult, honestly, to like listen to him describe this on Monday because he kind of doesn't make it sound. He doesn't make it sound. How do I put this? He describes things in the past as if they're present and things that are in the future as the past. And he's really difficult to follow because of the way that he uses his tenses when he speaks. So we were having to go back a lot to like listen to him and be like, okay, so do you have the files? Like, what are you talking about? Because he makes a statement in here that, oh, all the information is out there for the public to digest. And no, it wasn't. It wasn't out there. Sarah found it, but I'll tell you now, and I need to message her and ask her about like this little situation. I went to go look for this stuff on the Supreme Court website and like looked around Ada County, and it takes you back to the Supreme Court website, not the case of interest website, the Supreme Court website. And I used both of the case numbers in there, and I used Idaho Statesman, and a whole bunch of other stuff popped up, but not this one. Now I know that Sarah will call and be like, okay, what do I need to do? And she'll file it, and usually like the same day. She's so freaking quick with it. So I'm guessing that's probably how she got these. Because when I tried to search it, I couldn't find anything. And I was using my login. I was also trying as a guest. You know, so I don't know what's up with that. Maybe I'm just like really bad at looking for court documents. Because I don't have the best luck with that, honestly. Sometimes it just doesn't pop up. Now, it could have been my VPN maybe, but I also kind of don't think that at the same time because the other Idaho Statesman stuff is also like showing for me. Speaking of other stuff, let me show y'all something real quick. Did Sarah post this over here or did she post it on her YouTube page? It's really difficult for me to find Sarah's YouTube page on YouTube because I think she has like her search thing off or something like that. But I saw it on my, actually, you know what? I think I shared it. I want to show this to you because it's got to do with the EWU lawsuit, but not like directly, indirectly, but it's still important. And I shared it because it shows that one of the lawsuits that EWU is currently dealing with in Idaho when it comes to FOIA stuff and the way that it's not coming through the way that it should be for the rules. Right here. So EWU, let me make this bigger. EWU is also suing Blaine County Sheriff's Office for their public disclosure process. And it looks like they've like won that one, giving them like basically telling the Blaine County Sheriff's Office that they have to go back in and correct the way that they've redacted certain body camera. See, it says the court partially granted EWU's petition ordering the release of a previously withheld body camera recording while upholding other privacy-based redactions. And I'm like, holy shit, that's a good sign. Because this happened, this is Idaho. It's the same state, obviously, duh, that the Moscow stuff is happening in. So if this was a decision that they just made about, hey, you're overdoing things, go back in and fix it. Like, you know what you need to be doing. Why are you overdoing things? Let's be for real. Do what you need to do. Follow the rules, but also give the public the information that they're allowed to have. So that's a good sign. That's a really good sign. That's maybe how this is going to go. I don't know. I'm hoping so. I'm sure hoping so. Because again, I showed you guys yesterday on TikTok, that little crazy filter. And if some mom that wants to show off her baby taking their first steps can have a fuzzy filter like that, then the police department can use a little phone filter. I mean, come on. In order to redact the bodies enough to where we can see everything around them without seeing them. And Eric Warner's body cam is the most important piece in this entire case because he's the only one that walked into that room, according to everything that we can see. He is the only one, and the first one, which is the most important of all, the first one that walked into Maddie's room. And in his report, he says he walked around to the left side of the bed to check Maddie's leg for lividity, the same leg that the sheath was touching and right underneath, partially covered, meaning you should have been able to see it because it wasn't fully covered up by the blanket. It was sticking out to where it was noticeable from the bedroom door. All of those words that they said to us matter here. So if they can do that in those little TikTok videos, they can do that here 1,000 times better with law enforcement programming. They need to quit playing around. So maybe, just maybe, that'll mean something will happen here and we might actually be able to get Warner's camera redacted to a point where we can actually see the sheath without having to see Maddie's body, which is what they want, which is fine. I don't want to see the destruction. I know a lot of people do, and granted, it's not like I don't. I want to make sure that what we're being told is factual, but I also don't want those images in my mind. I don't want to sit here and see Kaylee's face beaten in. I don't want to sit here and see all of the stab marks in their cheeks. I don't want to see all that. I want to remember them in my mind the way that we met them after this, with their faces not destroyed. That's how I want to know them. I don't want to see that. They need to keep some of their dignity, you know? But everything else we should be able to see without the bullshit. So with Ann Taylor hiding financials, and with them hiding body cam, and with them hiding documentation, and with them telling us that things don't exist that we know that they do, I mean, are we ever going to get the truth of anything? I highly doubt it. I did get another closed thing today from the court too. I didn't even read which one they closed out. Hold on a minute. So you guys that were here know, oh, you sons of bitches. You sons of bitches. Wow. Okay, so you guys know how the other day they closed my FOIA request for that 108-page timeline that was apparently created between MPD and ISP, claiming that it doesn't exist. So today they closed out another one saying that these records also do not exist. And you want to know what it was? Handwritten reports. The handwritten reports from everyone that was there that day. They never made them fill out a handwritten statement. I said, I am requesting via FOIA the handwritten statements filled out by the following people regarding the 11/22 King Road homicides. Most of these should have been written on 11/13/22, but some may have been finalized on later dates. Dylan Mortensen, Bethany Funk, Josie Lauderin, Lyndon Beck, Emily Allant, Hunter Johnson. Written statements are a common step in the protocol for taking statements / getting witness testimonies from citizens when police are involved, be it a crime or just a simple report. The record you asked for does not exist. Therefore, your request is being denied. They didn't make them write anything. It's not shocking. This is not shocking at all. It's pathetic, but it's not shocking. Now, I did send a message back to them. Oh, I'm so sick and tired of them telling me that. I'm about to email them back and be like, well, I've tried and he doesn't contact me. So I messaged them and I said, I just want to verify about the 108-page timeline thing. Does this denial mean there was no timeline created in part by MPD along with ISP for the use of the LCPA, Latell County Prosecutor Attorney Office, in November of 2023? Or do y'all know it exists, but you're not the custodian, meaning it was sent off as work product maybe? Just wanting to verify completely since parts of this timeline have already been released and your office is stating it doesn't exist. And what did they tell me? The same bullshit that they told me weeks and weeks and months ago, and I never got any freaking response on. Contact Chief Dollinger. Well, if the little beta bitch would answer an email, then maybe that would be easy, but he's a coward and he refuses to answer questions. So thanks for nothing, Moscow, once again. Thanks for nothing, Moscow, once again. So I'm going to message them back right now and say, that seems to be the response y'all always give me when I have questions regarding answers to my FOIA requests, but he never seems to respond to emails. I have written him several times, never once received an email back. So what is your alternative solution? Sons of a bitches. I'm so tired of it. Send. I'm so done. Don't tell me to contact your damn chief who doesn't know how to respond to emails because he's getting caught in bullshit that he doesn't know crap about because he wasn't anybody of importance when this case started, and so he's a lost little boy. So dumb. Contact the person who's never going to answer you. Sure. Let me waste my life doing that. Sure. No, I'm not. No, I'm not. No, I'm not. Okay. Now that we've handled all that stupid shit, let's go ahead and listen to some of this. They don't like being held accountable whatsoever. I'm so tired of it. I'm so freaking tired of it. I am so tired of it. MDP, I saw your message. No, I emailed you back. It's on its way to me. It got to the P.O. Box company, and now they are sending it to me, but I haven't gotten it yet. Because when I got your email this morning, I checked outside. I checked my cameras. I was like, what is she talking about? But then I checked the thing. No, it's not here yet. It got to the actual thingy, but it doesn't. It's not here yet. And you know, all those are live. You can watch the Moscow City Council meetings on YouTube. They stream all of them. I've even watched one with stupid ass Dollinger sitting there doing some conversation stuff. That wasn't him. That was Blaker. She called Blaker. And we were going to go over that conversation that she had with him, but it was all about like his family and how hard it is for him. And I was like, this is a useless conversation. It's such a useless conversation. It's just a lot. It's so stupid. And especially since they politicized the shit out of this case. They got their firing squad out of this case, which apparently they're turning around and they're also going to be strengthening their punishments when it comes to people that mess with kids and stuff like that. Like, basically, you're going to automatically be getting the firing squad at this point, which I'm all about. You did something right. But this whole thing, what is the word for it? I guess cash cow. This entire case was a cash cow for this state. I mean, seriously. I don't know how they managed to do that because, like, it puts already, like, a negative aura on the state and on WSU because of, like, the way that the media puts everything out and just the way that humans are in general. You know that there's a killing in a place, all of a sudden it's got a different feeling to you. It also loses a lot of interest to people that want to go there. So they maybe lost some tourism and just found a way to launder it in other ways because there's no way that they spent that much money on this case with everything that they did not do. See, if we didn't have unknown DNA, if everything was tested to completion, if we didn't have so many missing pieces, if we didn't have so much proof that they didn't actually do a damn thing, then maybe I could believe a little bit. Believe it a little bit. I don't believe it at all. I don't believe it at all. I just don't. All right, let's listen to these knuckleheads for a few minutes while he talks about this court case thing.
So once this was all resolved, that, from my perspective, should be open to the public. These were public dollars. So we know that there was about $5.5 million spent. And so we want to understand how that money was spent, whether it was on the attorneys or what experts or all the details. It all sits in this sealed case file. So in December of last year, so 2025, the case gets resolved in July of 2025 with his plea. And then he gets sentenced to prison, which is where he sits today. That should all be open to the public to review from my perspective. So
yeah, he had his first preliminary the other day. I would like to keep up with that one. I would like to watch the Alec Murdahl retrial. I've really been interested in that case for like a super long time. I've watched a lot of stuff on it, but I haven't been able, like I've watched some of the hearing stuff, but to sit through all of the hearing stuff would be interesting. So I'm going to look at the court schedule. And I think what I want to do is we'll do a live going over what we know so far about the Alec Murdaugh situation. And then we're going to do a live to watch the preliminary thing together. I also want to watch the court hearing with the crazy lady who wrote the book, the clerk of court chick. That's just wild as shit to me. That lady's just crazy. That lady's just crazy. But I'm especially interested now because apparently there was unknown male DNA on the wife. And that just came out like over the past few days. I'm pretty positive from Murdaugh's defense team. Why that wouldn't have come out before this now retrial situation, I don't know, but it's interesting. Another one that I would like to look at, even though it's going to be difficult and I'm going to be pissed off even more than normal because it involves a child, is the piece of shit Adam Montgomery getting his shit redone. Yeah, we might watch that one. If I can like not be so pissed off enough to pay attention, we might watch that one too.
Essentially filed a public records request with that court and asked specifically about that sealed case file. And they'd never seen anything like this. And they had to figure out, like, what do we do here? And so I'm basically asking the judge who was reviewing and making decisions and approvals for how the defense spent the money, hey, I'd like to open that case file. And he received it as an unsealing process, which is a thing. Is a process. You don't have to be a member of the media. You could be somebody who just wants to.
Why is he saying, I guess I didn't catch it the last time when he goes, it is a thing, the unsealing process, which is a thing. What do you freaking think that we're doing right now? We're waiting for order number 4 in what? An unsealing process. Why is he sitting there acting like, oh, must be the first time that anyone's ever heard about it. Let me make sure they know it's real. Weirdo. No, sir, we're very aware.
Unseal a court file and they make a decision about that. Well, in filing for that, Ann Taylor opposed it. She objected to any of these being open with the understanding, and the argument was, well, this was always intended to be a sealed case file. That was her understanding, and they've used these in past cases, like the Daybell cases. There were case files like this that are sealed. And so she argued that it was attorney-client privileged. She argued that it had a lot of work product, which is a protected document in the state of Idaho, and I think in many other states. And you can use that to exempt certain records and public records requests. And so we basically were sitting in themselves sealed hearings with this judge.
Yeah.
We have an attorney. It's not me making the argument, but we have an attorney representing us and basically making opposing arguments with Ann Taylor on behalf of Bryan Kohberger about whether or not these documents should ever be released. Her position is none of those records should be released. It was always understood to be a sealed file. We prevailed in that case. The judge ruled on our behalf. He did say some of these documents are clearly exempt. There are things like educational and medical records, which would be protected, and other intimate details, things that just the public is not entitled to see about any defendant, let alone Bryan Kohberger. And so he invited Ann Taylor to object to specific documents as these things would be released, and we would get the case file. So again, we prevailed. Ann Taylor then, and this is the first time we've ever been able to reveal this because it was a sealed case file, but we had to get approvals just to even ensure, like, we can report about this now, right? Like, we've won, and there are documents that are now public, so it is out for public digestion.
And again, I looked and looked, couldn't find anything. Sarah's magical. Sarah is literally magical.
All that to say, Ann Taylor continued to object and has now appealed the case to the Idaho Supreme Court for review of this ruling. The Idaho Supreme Court, this is a case of first impression because it's just so unique. It's not often that these sealed case files get open, but part of the argument is that there are appeals. There are things that could prohibit the release of this information. But in Kohberger's case, that's not the situation. It's fully adjudicated. There are no appeals. And so this is kind of a residual consequence, sort of interestingly. And so the Idaho Supreme Court now will make the decision on whether or not and which documents from this sealed case file, which is now up for being unsealed, and whether or not we'll ever get to see all the details about what the attorneys made and what each of these experts.
Blah, blah, blah. Okay. So let's look at the documents. You get the gist about what he's trying to tell you guys. And the big thing about that is that he's saying that again, it's not like it doesn't include federal stuff and some of the experts coming in and getting paid. Some things aren't even included in what he's talking about now, which is just such a big figure. It's such a big figure. But this is also my thing. Like, if he has been able to come out and say, oh, we did the calculations and it's like $8 million, where's that paperwork? Because, I mean, I don't know if there's numbers in this stuff. I don't think there's numbers in this stuff. But he has written his article based off of stuff that he has claimed to have gone over. Because, see, he has this entire, like, graph down here that he put into his article. He had to have gotten these figures from someplace. So how come in his article he doesn't have these public documents that people can now digest that has anything to do with, like, the amount of things? Because, again, he's apparently grabbing these numbers from somewhere. He's putting them all up in here. So where's the documents he's getting the numbers from? That's what I want. So I guess I'm just going to have to ask for them myself. Whatever. Not the first time, obviously. So we'll get to that part eventually. Now, again, this is a little graph that he put together. He's claiming Latell County, and again, this is just with the 8 million that he's been told about or been able to calculate so far, and a shit ton, if not more than half of what actually happened here is still missing from these calculations. 3.1 million in Latell County, 1.7 from the University of Idaho. And again, they only spent about $3,000 on counseling. So the rest of this is all just dumb bullshit. Idaho State Police, $367.5 thousand. The Moscow Police spent $140,000. And then the Idaho Department of Corrections so far has spent $38.8 thousand. And then, of course, the public defenders, $2.7 million. And this is basically the defense itself, because Latell County was responsible for it up until the change when it went to this, like, defender's office situation. We were all here for that. And if you missed all of that, there's videos. There was a complete change in structure, pay rate. A lot of public defenders stopped being public defenders because it wasn't worth it to them anymore. But there was a separate contract created for Bryan Kohberger's defense team because of how high profile the case was. And there was like a closed session that happened in Judge Hippler's quarters where this private contract for this private pay amount, which was way more than all the other public defenders were getting, was signed. And in that, I think it was like, what, $200 an hour? More than that, between 180 and like 250, I think, depending on who it was, something like that. Yeah, it was a lot. It was a lot. Yeah, so here's the documents right here. Let's see what these are talking about here. We're going to go over them like we always do. So let's see. Make sure you guys can see everything over here on this end, okay? Move me down some. And make this a bit bigger. It's at 225. Is that good? Can you guys see okay? Am I in the way? No. Save that. And then do my banner thingy. Idaho Statesman versus Ann Taylor. I mean, I don't know. It's Ann Taylor. I'm just going to put Ann Taylor. Okay. So strange. All these little bitty separate things is so wild, bro. Okay, so this is the first one that Sarah has listed. We're going to go in order of the way that she has them here because they do seem to be in date order. The first two are from back in March of 2026. I'd like to see their stuff from December. So I'm going to try to figure out how to get some of their newer things. I want to see their original arguments. Okay, so this is coming from Bryan Kohberger's side of things. Motion to appeal from interlocutory orders. Comes now Bryan C. Kohberger by and through his attorneys of record and hereby moves this court to authorize a permissive appeal from the district's court's order on motion to unseal entered by the district court on January 8th, 2026. The district court in this case has already approved Mr. Kohberger's motion for permissive appeal on February 27th, 2026. See, there's all kinds of stuff that was happening before this. There's been stuff going on since December. Lots of movement already. Motion is made pursuant to IAR 12C1. Limited statement of facts and procedural history. Judge Monson, District Court Judge for the 2nd Judicial District of Idaho, has presided over this case in Latell County prior to the change of venue. That was the case number prior to the change of venue. Filed pursuant to ICR Rule 12.2 in conjunction with criminal case, all the case numbers. Pursuant to ICR 12.2, the case was filed and maintained ex parte and in compliance with and reliance upon ICR 12.2. Let's read ICR 12.2. Okay. Yeah, that's totally not what I was looking for. That's all about like cardiology, actually. Okay. Idaho Criminal Rule 12.2 governs motions requesting additional defense service and the court's determination of indigency for funding such services. Yeah, this is just the rule that they use in order to have this judge come in and basically be like, okay, well, whatever you need to just let us know, and then we'll handle it from there, is basically how I understood that entire situation. The district court sealed the matter pursuant to ICAR 32. After Mr. Kohberger was sentenced and his period for appeal expired, what? Kevin Fixler, the writer for the Statesman. So we're gonna, like, why is Ann Taylor saying his period for appeal expired? The appeal date deadline is September 2nd, as far as the majority people out here are concerned. So why the hell is Ann Taylor's side of things saying after Mr. Kohberger was sentenced and his period for appeal expired? Why is that coming from her side? That's a confusing statement coming from the defense. Kevin Fixler, writer for the Statesman, made a request through public records to have the file unsealed. Mr. Kohberger objected, or did Ann Taylor object? Because we don't really know, do we? This court ordered the case be unsealed, but recognizing many parts of the file would be subject to continued sealing in a redacted fashion. Mr. Kohberger filed a motion with the district court seeking approval for a permissive appeal from this order. The district court approved this motion, finding that Mr. Kohberger's request met with the applicable criteria for permissive appellate review under IAR 12A. Argument. Idaho Appellate Rules 11 and 11.1 set out a list of orders that are appealable to the Idaho Supreme Court as of right. However, the appellate rules also make provision for permissive appeals for orders that are not among those with an automatic right of appellate review. Under IAR 12, permission to appeal may be granted by the Supreme Court to appeal from an interlocutory order or judgment of a district court in a civil or criminal action, or from an interlocutory order of an administrative agency, which is not otherwise appealable under these rules, but which involves a controlling question of law as to which there is substantial grounds for difference of opinion, and in which an immediate appeal from the order or decree may materially advance the orderly resolution of the litigation. The first procedural step in seeking this discretionary rule is before the trial court that issued to judgment or ruling that is the subject of the request for permissive appeal. The trial court can thereafter enter an order either approving or disapproving the request, along with its reasoning for doing so. The ultimate decision as to whether a permissive appeal will be granted rests with the Idaho Supreme Court. Permissive appeals are designed to address legal issues that would otherwise tend to escape appellate review. Under Rule 12, permissive appeals are only acceptable in the most exceptional cases with the intent to resolve substantial legal issues of great public interest or legal questions of first impression. Mr. Kohberger submits that this criterion is met in his case. This court should grant Mr. Kohberger's motion for permissive appeal. No, as far as we're understanding, it's September 2nd. So I don't know. I'm very confused about why his side of things put that in here because that's not the case as far as Anjanette Levy is concerned, as far as quite a few other people that are of legal standard are concerned, and what the public's been made aware of. I don't know. I don't know. I don't know. This court should grant Mr. Kohberger's motion for permission to appeal. The underlying trial court ruling on the motion to unseal records falls within the scope of an otherwise non-appealable order. Idaho Appellate Rule 11 sets forth appealable orders from a district court, while Rule 11C permits the appeal of an order made after judgment affecting the substantial rights of the defendant or the state in criminal proceedings. This order does not come out of the primary criminal case in this matter. Instead, it is part of the separate civil case that was opened in order to address ex parte request for funds. There is no counterpart to the provisions of IAR 11C9 when it comes to civil cases. In addition, none of the judgments or orders identified in IAR 11A appear to subsume orders of the type at issue within the request. Accordingly, this court's order to unseal is properly the subject of a motion for permission to appeal under IAR 12. The underlying disputed questions in this appeal turn almost entirely on legal questions rather than factual disputes. Given the general dearth of case law addressing these issues and the substantial and weighty interest involved on both sides of this issue, Mr. Kohberger submits that this appeal involves a controlling question of law as to which there is substantial grounds for difference of opinion. The trial court in this case agrees with this conclusion, having determined that this case presents a novel question of law and that neither the parties nor the court were able to locate any controlling Idaho case law on the legal questions that were litigated before the district court. Finally, this appeal presents both substantial legal issues of great public interest and legal questions of first impression, making this case ideally suited for permissive appeal. As a general matter, there is little to no case law in Idaho addressing the degree to which the public may seek to unseal detailed records of court orders for funds in a criminal case. And while the degree of publicity surrounding Mr. Kohberger's case is beyond that normally attendant on a criminal trial, it is all but certain that these issues will recur in our modern era of extensive media coverage of criminal trials. While other courts will no doubt have to grapple with similar issues in criminal cases, there is almost no case law from our state appellate courts to guide these judges in rendering a decision. Because of this, Mr. Kohberger asked that this court grant his motion for permission to appeal. And again, for those who might be hopping in to hear that statement and nothing else, this is not about the criminal case. This is about financial documents and appealing them staying sealed when the public wants them unsealed. I want them unsealed. Everyone should want them unsealed. Here too, the district court agrees with this assessment. And in its order approving of Mr. Kohberger's request for permissive appeal, the trial court determined that the issues presented in this case in particular represented legal issues that were of great public interest. For these reasons, Mr. Kohberger respectfully requests that this court grant his motion for permissive appeal and further grant him leave to file a notice of appeal in his underlying case. Now, okay, so this one right here actually is the attachment for this one. And this is dated 1/8/2026. I'll need to go in and reprint these and separate them out. Okay, so then this right here would be, I'm going to assume, well, let me see if there's another one after that. No, I mean, not like before dated. Okay. So the one in January that we're going to read is the motion order. Is that what it said? And then there's the one from February. So the two that were mentioned in this right here. So this is going to be, yeah. Okay. So this is going to be the order on motion to unseal talked about right here, January 8th. And then the approval already for February 27th. So I guess I'm just confused like, if the order for permissive appeal was already granted, then why are we doing another one? I guess that's why I'm a little bit confused here, just a little bit. I don't know. Let's just go down here and read these now. Okay. So this is the one that was filed January 8th, 2026. Analysis. This is the Idaho Statesman paperwork. Let's see. This matter is before the court on the Idaho Statesman's request to unseal the civil resource file. A hearing was held on this matter on December 11th, 2025. The defendant, Bryan Kohberger, was represented by Ann Taylor. Idaho Statesman was represented by Kirsty Kennedy. The court, having considered the briefs of the parties, having heard the arguments of counsel, and being fully advised in this matter, hereby render its decision. Analysis. The Idaho Statesman, hereinafter the Statesman, submitted a public records request for civil resource file related to defendant Bryan Kohberger's defense. Because the court previously sealed that file under ICAR Rule 32I3A6, it treated the request as a motion to unseal. Kohberger objects, arguing civil resource files are not public and that the Statesman's motion seeks disparate treatment of his confidential information because his defense used public funds. The Idaho Supreme Court has the inherent power to make rules governing the procedure in all of Idaho's courts. This court's jurisprudence and the Idaho Constitution make it clear that this court has the inherent power to make rules governing the procedure in all of Idaho's courts. The inherent power of the Supreme Court to make rules governing procedure in all the courts of Idaho is hereby recognized and confirmed. This rule is adopted pursuant to the Supreme Court's authority to control access to court records, as recognized in the Idaho Public Records Act 74-104. The public has the right to access the Judicial Department's declarations of law and public policy and to access the records of all proceedings open to the public. This rule provides for access in a manner that promotes accessibility to court records, supports the role of the judiciary, promotes governmental accountability, contributes to public safety, minimizes the risk of injury to individuals, protects individual privacy rights and interests, protects proprietary business information, minimizes reluctance to use the court system, makes the most effective use of court and clerk of court staff, provides excellent customer and avoids unduly burdening the ongoing business of the judiciary. The customer service one in there is wild. Wild. Kohberger asserts that ICR 12.2 shields the reference material from public disclosure. The court disagrees. ICR 12.2 expressly requires that motions seeking public funds be filed ex parte, but it contains no provision declaring such motions permanently exempt from public disclosure, nor does it automatically seal filings made under the rule. This court sealed the file pursuant to ICAR 32I5 by order filed January 18, 2023. Accordingly, the court may lift that order to seal under ICR 32AR5. Further, even if ICR 12.2 were construed to impose an automatic bar to disclosure, ICAR 32A governs access to judicial records and supersedes any conflicting rule. Any purported automatic seal therefore remains subject to unsealing by the court. ICAR 32I5 addresses orders to unredact or unseal court orders. 5. Orders to unredact or unseal. And A says, in any order removing redactions or unsealing records, the court must explain its reasoning for the decision. Those reasons may include, but are not limited to, 1, a determination that none of the factors listed under subsection I3A preclude release of the records, and 2, a determination that release is permitted elsewhere in court rule, including other subsections of ICAR Rule 32. The order must also specifically identify the records to be changed, and a copy of the order must be served to the clerk of the district court. The court may enter an order unsealing records if it determines that none of the factors listed under subsection I3A preclude release of the records. Those factors are: The records contain highly intimate facts or statements, the publication of which might be highly objectionable to a reasonable person. The records contain facts or statements that the court finds might be libelous. The records contain facts or statements that may compromise a person's financial security or could reasonably result in economic or financial loss or harm to a person who has an interest in the records. The records contain facts or statements that could compromise the security of judicial branch personnel, property, or sealed or exempt court records maintained by the judicial branch. The records contain facts or statements that might endanger a person's life or safety. That it is necessary to temporarily seal or redact the records to preserve the right to a fair trial. The records contain personal data identifiers that should have been redacted pursuant to Idaho Rule of Electronic Filing and Service 15, Idaho Rule of Civil Procedure 2.6, and Idaho Rule of Family Law Procedure 218. The court's basis for sealing the file related to the sixth factor listed above, that it is necessary to temporarily seal or redact the records to preserve the right to a fair trial. The need, blah, 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 is mute. Yeah, that's what I was about to say, that like we're not even dealing with that anymore. Kohberger's guilty plea and waiver of appeal render that basis moot. Yeah. Both parties rely on federal appellate decisions that specifically address disclosure of defense expenditure records under the Criminal Justice Act 18 USC 3006A. Those decisions are persuasive, but arise under a statutory scheme that expressly governs disclosure and protects attorney work product and privileged communications. ICAR 32 contains no comparable disclosure rules or exemptions, so the sole question here is whether to unseal the records under ICAR 32. So does this mean that they went through the records and they don't see anything that looks like it would be attorney work product or privileged communications? No comparable disclosure rules or exemptions. Huh. Interesting. Okay. ICAR 32 contains no comparable disclosure rules or exemptions. So the sole question here is whether to unseal the records under ICAR 32. Applying the factors in ICAR 32 I3A, the court cannot find a basis to keep the entire court file sealed. Kohberger asserts that attorney-client privilege and or work product doctrine applies. Under ICAR 32G1, documents and records to which access is otherwise restricted by state or federal law are exempt from disclosure. Idaho statutory provisions recognize and protect the attorney-client privilege and work product, and there's a footnote. Regarding attorney-client communications, Idaho Code 9-203 states, there are particular relations in which it is the policy of the law to encourage confidence and to preserve it inviolate. In addition, Idaho Code 74-105-18 exempts from disclosure under the Public Records Act records containing information protected or exempted from disclosure under the rules adopted by the Idaho Supreme Court, attorney work product, attorney-client privilege communications, ... Yeah. Okay. All right. As noted above, ICAR 32 I3A1 permits that court to seal or redact a court record if the record contains highly intimate facts or statements, the publication of which would be highly objectionable to a reasonable person. Consistent with ICAR 32 I3A, the court concludes that attorney-client communications and attorney work product contain highly intimate facts or statements, the disclosure of which would be highly objectionable to a reasonable person and therefore warrant continued protection. Okay, so there is stuff in there then. So it's going to probably take them forever and a day to go in and redact whatever needs to be redacted. We already know how they play that game. The Statesman argues that Kohberger bears the burden to demonstrate how each document is privileged or otherwise protected, and the court agrees. The burden of showing that information is privileged falls on the party asserting the privilege. So they're going to have to go in and argue every little one. I bet you she'll milk the shit out of her hourly wage just to do that. Let's be serious. The court has conducted an initial review of the case file. Pursuant to ICAR 32 I3, the court has identified a category of documents that shall remain sealed because they contain information exempt from disclosure under ICAR 32G and or relate to medical or educational records. We kind of figured we weren't going to get any of that stuff anyway. even though this is about funding to pay for certain things, we pretty much know it's going to probably never happen where we get like full on psych reports and stuff like that. It's probably not going to happen. The court finds that these records contain highly intimate facts or statements, the disclosure of which would be highly objectionable to a reasonable person. The court notes that Kohberger made only a general objection to unsealing all the documents in this file. Should Kohberger wish to make objections to specific documents, he may do so. The court will require him to identify why redacting of materials is not an acceptable arrangement and detail with specificity why the document should be sealed from both a legal and factual standpoint. So this is going to go to court. This is going to go to court. And they're going to have to stand up and say, for this document for document number 5 on the list, this is the very specific reason, and this is the very specific information in this document that means that regular redaction of just that piece of information is not enough because the context around it alone will give everything away. Therefore, the full thing needs to remain sealed. This is going to be a document by document argument. This is going to be a long journey. This is going to be a long journey. Simply citing a rule without more is not a sufficient response. The submission shall be filed or lodged with the court in camera, meaning in the room with the judge, not actually on camera. We're not going to see none of this. We're probably just going to see the result. If the court concludes that a particular document should be redacted, Kohberger shall provide a proposed redacted copy of the document that complies. So if the court says, okay, fine, then the defense team has to go in and they have to make the redactions themselves and then present it to the court, and the court then gets to decide if it complies with the rule or if there needs to be changes made. This is going to be a lot. This is going to be a lot. Oh, this is from last night. Well, thank you for joining again last night, Sherry, just in case you're in here. I appreciate that. Thank you for the 5, Lori. I appreciate that. Thank you so much. Well, welcome back, Sarah. Welcome back, Sarah. I know it says new member, but then it says member for 5 months. I don't know why it's doing that. How very strange. I appreciate that. Thank you so much. Thanks for showing up in here today. I appreciate that. Thank you. Yeah, this is wild. Okay, under the unique circumstances of this case, the court therefore grants in part the motion to unseal the file in this matter subject to the court's further review of any objections made by Kohberger. And then there's a second thing. The court recognizes that a decision to grant or deny relief under ICAR 32I is discretionary. Okay. Kohberger shall file his response within 45 days of this court's order. Further, in acknowledging the novelty of this issue and the likelihood of an appeal, and to prevent premature disclosure, this case file shall remain sealed until Mr. Kohberger has had an opportunity to make any specific objections and the court has had an opportunity to rule on those objections. So this is the one from January 8th, 2026. Now, the last 3 pages here, or 2 pages, 3 pages here, are the order granting the motion for the appeal. This matter, this was in February 27th, 2026. This matter is before the court on Mr. Kohberger's motion for permission to appeal from interlocutory orders in a stay of proceedings filed January 22nd, 2026. The Idaho Statesman filed its response on February 11th, 2026. The court, having considered the briefs of the parties and being fully advised in the matter, hereby renders its decision. And then it's just the background all over again. It's all the same stuff we just read. And we read these rules already. And then it just says, let's read the bottom right here. This case presents a novel question of law. Neither the parties nor the court were able to locate any controlling Idaho case law on the issue of whether civil resource files and funds granted pursuant to Idaho Criminal Rule 12.2 are subject to public records requests. As demonstrated by the briefing and arguments of counsel, this matter involves a question of law as to which there are substantial grounds for difference of opinion. Further, the court recognizes that Mr. Kohberger's companion criminal case has generated national and global interest and is therefore of great public interest. The court finds good cause to grant Kohberger's motion for permission to appeal from interlocutory orders. Okay, and then now this says it's 18 pages, but when I went through it, it looked like it was a lot of repetition of what we already read through. Let me make sure. Yeah. Yeah. So this is the affidavit of Ann Taylor and Doris Lunsford, I guess. But there's really not a lot of anything new in this one. So we're just going to read through the things. Oh, hey, Sarah. It is a lot of repeats. How did you find these? I went, I logged in, I looked without logging in, I looked a couple different places and I could not find these, even with the freaking case numbers on the thingy. I'm just not good at finding documents, I guess. I don't know. Good at reading them. Oh, see, I knew it. I told y'all. I said she probably called and requested them because she does that and she gets them like the same day. I figured that. Okay. So that makes sense that they're not on there. So I'm not horrible at finding the documents. They're just literally not there for me to find. Thank you. Okay, good to know. Good to know. Good to know. All right. So this starts right here because we know they're over the age of 18. Okay. On March 13th, 2026 at 10:48 a.m., Doris Court filed a motion to appeal from interlocutory orders with the district court to meet our filing deadline. Since the filing had the district court case number, we thought it needed to be filed within that case until it was assigned a Supreme Court case number. On March 16th, 2026 at 8:04 a.m., we received an accepted court filing email for our motion to appeal from interlocutory orders. On March 16th, 2026 at 12:33 p.m., we received a call from the Ada County Clerk's Office to let us know that the motion to appeal from interlocutory orders filing was likely filed in error since there was already an order granting permissive appeal and that we would need to file it with the Supreme Court as a new case. On March 16th, 2026 at 12:50 p.m., so all this is going on the same day so far, one like the 13th and then the rest of it on the 16th. We filed the motion to appeal from interlocutory orders with the Supreme Court and included a comment to the court in our attempt to timely file the motion. Doris immediately called the Supreme Court clerk's office regarding this filing and asked for further guidance to ensure we are able to continue to meet our deadline. We received a call back from the clerk's office to let us know that the filing would be rejected so that we could fix the heading of the document to in the Supreme Court and also include a request motion affidavit of our attempts to meet our deadline for filing a motion to appeal. So they were also just as confused as to why it was being submitted because there was already one being granted. And then they also didn't even know where to file it. Okay. And see, this is the same one that we just read through. I just want to make sure is there anything else? 1-8. No, that's the same one. See, I told y'all this second one was literally just like the whole thing was repetitive. She just attached it on here. 227-26, yeah. Okay, so this is the receipt for it being filed. Filing accepted, envelope number, case number. Case style is redacted. Weird. And Taylor to appeal interlocutory download document. Huh. Okay. So now we'll go to, let's see, that was 1, 2. Okay, notice of cross appeal. So I guess that means because it's going in the regular court, like Ada County, and it's also going to Supreme Court, they're calling it a cross appeal. Okay. Here's the Ada County number, I guess, for this. And then the Supreme Court number. Notice is hereby given that the above named respondent cross appellant, the Idaho Statesman, appeals against defendant appellate cross respondent Bryan C. Kohberger to the Idaho Supreme Court from the order on motion to unseal entered in the above entitled action on January 8th, 2026. The Honorable Mark T. Monson, District Court Judge presiding. The Statesman has a right to cross appeal to the Idaho Supreme Court pursuant to Rules 11G and 15 of the Idaho Appellate Rules. The order described in paragraph 1 above is appealable pursuant to Rules 12D, 11G, and 15A of the Idaho Appellate Rules. What is she appealing? What exactly is she trying to appeal here, though? Because I'm confused. Okay, let's stop for a second. Just freaking stop for a second. Okay. I'm not confused, but I'm confused. Like, I understand what's happening. I'm not dumb as shit. I understand what I'm reading. What I'm not understanding is if they've already granted her the ability to go in and say, hey, we don't want this to be public. Here's the version of the redactions that we feel follows the rules. Let us know what else we need to do. If that kind of leniency has already been granted, what is she appealing with the Supreme Court? Is she trying to just be like, oh no, we need to keep it hush altogether and not go through all of the process that the court just allowed us to have? I guess I'm just not understanding what's her point of filing with the Supreme Court when the court's already telling her, yes, we can see that some of these things do need to be kept private, do need to be kept sealed. We're going to work with you on there. And now I understand why Kevin Fixler is maybe acting that way, because we're seeing them give her the lenience that she's asking for, and now she wants to take it a step further. I think I get why he was saying what he was saying. But this is only the one side. We don't know what the hell the state's hiding either. So this is just one part of this. But I think I'm understanding his point now, because I don't understand why she's deciding to take it to the Supreme Court when she already got something that she asked for. The Statesman will respond to issues on appeal raised by Kohberger and also asserts the following preliminary statement of issue on cross appeal. Did the district court err in holding that the attorney-client privilege and the work product doctrine may apply to documents or records in Kohberger's civil resource file? The statement does not request any transcripts in addition to those already requested in Kohberger's notice of appeal. The Statesman reserves the right to later request that the record be augmented if necessary. In that event, the Statesman requests electronic transcripts. The Statesman does not request any additional documents to be included in the clerk's record other than those designated by Kohberger in his notice of appeal. The Statesman reserves the right to later request that the record be augmented if necessary. The Statesman does not request any documents, charts, or pictures offered or admitted as exhibits to be copied and sent to the Supreme Court. Service of the notice of cross appeal has been made upon the court reporter. No additional transcripts has been requested by the cross appellant. No additional transcript has been requested by the cross appellant, and therefore no reporter's fees are due. No additional clerk's records or agency record documents have been requested by the cross appellant, and therefore no additional clerk's fees are due. No appellate filing fees have been paid, and service has been made upon all the parties required to be served. Okay. Alrighty. Okay. Here's the last one. I think it said it was 2 pages. Okay. Supreme Court paper. It's so much different how they do their fonts. Everything is so different. Okay. A motion to appeal from interlocutory orders and affidavits of Ann C. Taylor and Doris A. Lunsford were filed by counsel for defendant on March 16, 2026, requesting this court for permission to appeal the district court's order on motion to unseal filed on January 8, 2026. The Idaho Statesman's notice of non-opposition to motion to appeal from interlocutory orders was filed by, did I even say the word? I felt like I just spoke some sort of literally out of planet language there, like from Star Trek or some shit. Interlocutory orders was filed by counsel for the Idaho Statesman on March 27, 2026. A motion to seal the appellate records was filed by counsel for defendant on April 13, 2026, therefore after due consideration. It is ordered that defendant's motion to appeal from interlocutory orders is granted, and the defendant is granted leave to appeal by permission from the district court's order on motion to unseal filed on January 8th. It's further ordered that counsel for defendant shall file a notice of appeal with the clerk of the district court on or before 21 days from the date of this order, which shall proceed as if from a final judgment or order entered by the district court. What's the freaking date? April 17th. Oh, way past all that. So there should be like more things happening then. It is further ordered that counsel for defendant shall file a notice within 21 days, blah, 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 blah. It is further ordered that defendant's motion to seal the appellate records is denied without prejudice. Defendant may move to seal particular documents or to file redacted documents. Interesting. Defendant's motion to seal the appellate records is denied. So those should be public information then, yeah? That should be public information. Huh. Interesting. Well, oh, I didn't even pop the page back on there. Hold on. Let me show y'all this last one. I didn't even realize it wasn't showing up. See, it's just this. This was in April. So I don't know when the next thing is. Yeah, I just now realized that. I can't see it on this side. I need to get my second screen put on here. I gotta fix the driver on my computer so I could do the second screen. Yeah, I don't understand honestly what this is going to the Supreme Court for, other than she wants to hide some more stuff. Because like I said, the court, damn light in the damn mermaid picture is reflecting real bad. I mean, it should be. Yeah, he said that they received some stuff, but he said available for the public to digest themselves. And I'm like, where they be then? So I don't know. I'm gonna have to call up there and see what I can figure out about like the past stuff, the stuff that they're claiming isn't going to be sealed, the stuff that's apparently supposed to be available. Like, where is all that? But it's still just interesting. It's still just interesting that they are telling her, okay, we're going to give you the chance to tell us out of this segment of documents that we say are client attorney privilege and do contain work product that has sensitive information in it. We're going to give you the chance to say, hey, we need this completely sealed because doing regular redactions isn't going to work. It's going to give away too much information. And here's the reasoning as to why. It can't be, oh, due to this rule, it needs to be sealed. The judge wants a specific reason. So if there's a sentence in a document, that sentence has to be read out loud to the judge. And then the reason why that sentence is so, I don't know, important enough to need to be sealed, the exact reason needs to be stated. It can't just be, again, oh, because of this rule. No. Specifics or nothing. And she's like, okay, well, I don't care that you're giving me the opportunity to sit here and actually redact some of these things and keep some of this stuff sealed. I want all of it sealed. So F what you just did, even though you're being nice to us, in my opinion, And we're going to go ahead and take it to the Supreme Court because we want everything sealed off. Yeah, but I don't understand for what. Nothing should be sealed. If this is done and over with and there's nothing else to be done, then why is she trying to hide the financial records? We already know that they didn't bother testing unknown DNA. We already know they didn't bother testing any further the hair in Ethan's hand. We already know how many people were swabbed and not compared. We already know a bunch of the stuff that wasn't done here. I highly doubt there's going to be anything in there that's going to shock us. Honestly. Besides just like the astronomical numbers for things that aren't going to make any sense because it's all a bunch of bullshit. This is stupid to me. This is so dumb. But it is what it is, I guess. We're just going to watch it. See, and that's what I don't understand. See, that's the part that I'm hoping it is, that she doesn't want stuff that they plan on using coming out. But that statement that she made about the appeal deadline already being passed, that doesn't make sense to me. Unless they're talking about the appeal deadline for like the case itself, but that's not how the wording was in that one document. See, that's what I was about to ask, if like you knew if they had a date for anything. Yeah, I figured it would have to be straight up transcripts. So I wonder since they're wanting like some of this stuff to be unsealed, like since the court's basically saying this needs to be unsealed, but we're going to let you have a little leniency. I wonder if we could go in and ask for the transcripts for that December hearing. I'd be curious to read that transcript. Isn't this all crazy? This is literally all crazy. And I don't know, Ann Taylor is going to have to make this make some sense. And if nothing pops off anytime soon, then I'm just going to be questioning shit all over again, because I don't even understand what it is they're trying to like do here. I really don't. I really just don't. Oh my God. Okay, so Rochelle just sent me something and I feel like I need to show y'all this. Okay, so y'all know how I despise CrimeCon. I think it's a freaking joke. And if you look into the structure of that organization, you know that it's nothing but a way for whoever created that thing to just get shit tons of money out of a bunch of people who don't pay attention. On top of my disgust for CrimeCon, I know that some of you guys know there's also a crime cruise. Because there's not enough people that get killed or go missing on cruise ships as it is. We've got to go on a crime cruise. My God. Are y'all ready to see who the freaking keynote speaker is? Well, I don't know if you can call it a keynote speaker, but are you ready to see who one of the main speakers are going to be later on this year? Girl, you knew. Where you at? Where you at? You knew what you were doing sending me this shit. Are y'all ready? Are y'all ready? Catherine freaking Ramsland. And the guy that thinks you're a pedophile if you want to look at crime scene photos, Chris Hansen himself. No, honestly, I feel like it being Catherine Ramsland is worse than it being the damn Goncalveses. What? An immersive experience? You mean like how Dylan has dreams about being killed and murdered and she allows it to happen because she can control it? That kind of immersive experience? Why does a crime cruise need an immersive experience? See, these people think it's entertainment. This is where I draw the line. See, stupid Steve can sit there and say stupid shit like, oh my God, these kids are not characters in your book, while he sits at CrimeCon. Catherine Ramsland and 764 boy himself. Isn't it freaking weird? Florida. It's going to come out of Florida. Fort Lauderdale to Cozumel. How disgusting. I'm sorry. This is disgusting. This is straight up disgusting. And the fact that this joke of a woman thinks that this is where she needs to go. And Nate Eaton, of course you're going to be there. Ugh. This is such gross behavior. I don't give a shit. That is so gross. Such gross behavior. Unbelievable. Unbelievable. Why am I still so shocked of things? You think that we wouldn't have a shock factor? We have. You know what? I'm proud of us. Let's take this for what it actually is. I'm proud of us. All the bullshit that we have seen over the past few years, and we are not desensitized to the point to where this doesn't piss us off. That still bothers us. Seeing something so disgustingly disrespectful, let's be for real about what this whole thing is, still bothers the majority of us. I'm proud of us for having some sort of humanity left after all of this. Somebody has to keep some, because damn, unbelievable. Oh no, it's not. As a matter of fact, people, as far as I'm understanding, people that volunteer have to pay to do so, which is crazy, crazy as hell. Wild. All right. Whew, I'm gonna get off here. We will be live later tonight. Let me go ahead and get the thingy-ma-blubber up and give you guys the link real quick to go over the Goncalves' interview. That's going to be lovely. Oh my God. That's going to be so fun. Let me give you all this link real quick. Yep. See, volunteers pay to go. Like you pay to get in and then you work the damn whole thing for free as a volunteer. You don't even get to walk into the building for free when you volunteer to work the whole thing for free. You still have to pay to get in, to volunteer. That's just the first thing that went insane. For real. All right, there's the link right here. This is the one that I've been telling you guys about for like over a week now, and I don't care what anybody says. This whole thing was so weird. Just the interview itself, like we know that they're ridiculous, but the way that these people like talked about this incoming interview was so freaking strange because it's over an hour long, so it can't go in its full length over on TikTok. But that's the only place they were talking about it, was over on TikTok. They have an entire podcast page. They didn't talk about it one time on their podcast website. The YouTube channel that they have is where they posted this interview, but they never posted the shorts on YouTube that they had on TikTok to tell people on YouTube they were going to be talking to the Goncalveses. It was all very odd. I even showed you guys like twice us going through and trying to find where the hell this was supposed to go because they hadn't posted anything about it. So finally, we finally see a little short And it talks about how it's going to be put on their YouTube page. So we go back to their YouTube page just to see if they've maybe said anything on their YouTube page. And they never said anything on their YouTube page. It posted there. That's where I watched it. That's where I got the screen recording from that we're going to go over tonight. But they never talked about it being an upcoming thing. They didn't premiere it. They didn't tell their audience it was coming. The whole thing was very odd. Very strange. Very strange. It's just a lot. It's just a lot. So much. Okay. Be prepared, because it's like, I don't even know how much time is there in there. And I still haven't decided. I still might go in because I have plenty of time. I still might go in and take out some of the not crime talk stuff. But I don't want to at the same time because it's like stories about Kaylee. And I don't want to take all of that out of there because she's like one of the 4 reasons why we started this whole thing to begin with. I'm going to keep it in there. It'll just be the parts I won't have a comment on because I'm not going to talk shit about them talking memories about Kaylee. That's not the point of this. I'm going to leave it in there. We'll go over it tonight. Just be prepared. Okay. Be very prepared. But I will see you guys later. Try to relax. Remember that it's Wednesday because I didn't remember that it's Wednesday, but it's Wednesday. And also do not forget tomorrow morning, we are going to go live at 11:45 to go over the plea deal change hearing. Because even though the stuff was signed on the 30th and we found out about it on the 30th, the hearing where Bill Thompson stood up with his infamous statements that I use in my intro now about how they can't put him anywhere and they can't connect him to nothing. That's what we're going to be going over tomorrow morning. That's what we're going to be going over tomorrow morning. That one is also, I thought it was Tuesday too. I came on here saying happy Tuesday. Sounded like a crazy person. No. So I bought a spray. I think that's why I didn't get any redder today. Because we went back today and I feel like I'm darker instead of being more red. So yay me for not, forgetting. But I had to hella wash it all off my hands because you can't have sunscreen on your hands and then bait a hook because the fish don't like the sunscreen stuff. It's like a repellent. So even if the shrimps are all shrimpies, they're not gonna go eat them because it smells like sunscreen. So I'm actually kind of surprised my hands didn't get more burnt. But you know what? We do what we got to do. We do what we got to do. I'll see you guys in a little bit. But again, if you're on blood pressure pills, make sure you took it because you guys already know how this stuff ends up being, Thank you again for rejoining again, Sarah. I appreciate you being in here. Thank you for the 5 again, Lori. And again, even though Sherry joined last night, thank you again for joining. I very much appreciate you. You guys have a good next few hours, and I will see you guys soon. Not very much longer. Get some rest. See y'all. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you have not subscribed already. And please don't forget to make sure that the notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives.